imperial tables. Jefferson went on to serve France as the inaugural US ambassador, and Madison was deeply engaged in putting the new American constitutional document into effect. The constitutional trajectory of these two countries were, however, different. Question is asked, why is it that the inaugural constitution drafted in Philadelphia in 1789 has survived for more than 220 years and keeps counting, whereas the French Constitution of 1791 lasted a little more than a year, to be followed in French history by 14 more constitutions. A recent study of the endurance of the national constitution adds an old joke that a man goes into the library and asks for a copy of the French Constitution, only to be turned away with the explanation that the library does not stock periodicals. Despite the large number of amendments to our Constitution, it will never be said so about us. The story of the endurance of the Constitution, as we move into challenging global exchange of ideas, people, technology, and most of all human values, which are common to all humanity, the history of the Indian Constitution will be a shining example for global adoption. The political forces and governance institutions are undoubtedly the pillars of democracy. Their commitment to democracy and rule of law are generative factors which keep people's faith in democracy and rule of law. Where constitutions have not endured or have been under constant endangerment, we see the lack of stability of the political forces or the lack of commitment to rule of law and democracy. Without citing examples, one can say that even in those countries and on those testing occasions, constitutional courts have endeavored to stand by rule of law. But more importantly, is the vibrant presence of the constitutional courts that keeps people at the center of constitutional articulation and democratic practice. As constitutional scholars, we can look at the distinctive role played by the legislature and the institutions of governance in striving to effectuate our constitutional promises. Story, however, will be incomplete if the role of the Supreme Court is not seen and debated in the remarkable phenomena of endurance of the Constitution of India. So it is we talk about the importance of distinctly Indian constitutional legality. This Indian constitutional legality, which is a product of the exchange between the court and the governance institution, is more importantly a singular product of the courts. In the course of 75 years, honorable judges who have come to adorn this court have internalized the highest driving values of the Constitution in ways beyond legal and constitutional thinking elsewhere. The tallest members of the legal fraternity and the giants in the bar, whose names are too many, are equal partners in this regard. See, my illustrious predecessor have added to the rich tapestry of a constitutional jurisprudence. At the inaugural sitting of this great court, Venerable Sri M.C. Setalvar, the first Attorney General, rightly spoke about the far-reaching influence of this court will have on the life of the nation, and those are prophetic words. Recent scholarship on constitutions in a deeply divided society also looks at India. It is assumed in the study that the process of constitution making is necessarily different from Western societies, which are said to be ideologically and culturally united. These studies keep Europe and America out of the scope of such analysis. In a contribution titled Justice, Equity, and the Making of the Indian Constitution, an academic in the Department of History, University of Colorado, observes thus, I quote, "What intrigues the scholars is a remarkable and unexpected survival of the Indian Constitution for over 70 years, given their foundational assumption of a deeply divided society, or alternatively, as the famous economist and one-time American ambassador to India, J.K. Galbraith, called it a functioning chaos," unquote. I stand by the contributor to the article in the statement that such scholarship is based on an imperialist and orientalist epistemology, that constitution making and democracy in their ideal form can only be found in Western nations that are sovereign because they are inherently united. In May 1950, A.K. Gopalan petitioned the Supreme Court soon after his inauguration. The engagement of the court on the issue of liberty from then on has been one of the most fascinating journeys. And when we are in constitutional lawmaking post Maneka Gandhi, one can still say that the liberty jurisprudence of the court has been and will continue to be one of the most important factors for constitutional endurance. The picture before the Supreme Court in the first few years of its inauguration and the classes of people who access the court raising concerns of infringement of their fundamental rights, one can say that what we have today is an enlarged graph of the same. The Law Commission of India in 1958, in the report on administration of justice, said, I quote, the country stagnated for 150 years of foreign rule. Our legislatures are now trying to advance the nation in all directions in their zeal to achieve quick results. They have not infrequently enacted legislations infringing with the vital and daily functions of the citizens. In order that their policies may go forward uninterrupted, they have endeavored to entrench the executive and succumb to the temptation of restricting the powers of the court. In terms of social, economic, and political arrangements and processes, and in terms of transformation of the lives of people, India of 2024 is not of India of 1950. While universally, all countries, through their constitutions or otherwise, endeavor to make the lives of people secure and comfortable, the genius of the institutions of different countries present a mosaic of a veritable field of academic scholars and legal pundits. If you look at the class of people who came to Supreme Court in the year 1950 to 1955, namely the Communist Party newspaper editor facing censorship by the central government, that is Ramesh Thapa. And today, what a vibrant set of principles and arguments we have on censorship. A schoolgirl refusing to comply with a government order, forcing her to study in her mother tongue, came to this court in State of Bombay versus Bombay Education Society. The deep importance of linguistic and cultural affinities to flow in a balance with public order and social relevance has been set by such proceedings. A Hindu man unable to take a second wife because of reforms in Hindu marriage law, Narasu Mali. And the field is now occupied by women's equality in succession to property and becoming co-partners. The saga of 9 scheduled adjudications is a story of the balance between social necessities and governance adventures. To capture debates and discussions happening in an expanding literature on the transformative constitution of India in a few minutes is a daunting task. As the nation continues to pledge itself, which means the pledge of the people, the governance institutions, and the judicial institutions, as the three angles of a triangle, the legal fraternity has the most noble task of standing by this triangle of faith and pledges. Today's celebration of the inaugural day of the Supreme Court, I hope, will continue to reverberate and constantly promote the constitutional consciousness of we the people of India and share this with all humanity. I thank the Honorable Chief Justice and the Judge of the Supreme Court for being able to make this very humble speech today in the most important occasion.
This is a momentous day where, for the first time in the history of the Supreme Court, a ceremonial bench is sitting to commemorate the coming into existence of the Supreme Court. This has become possible due to dynamic leadership, foresight, and initiative of Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud. The Supreme Court is the institution where judges from all across the country come. They play their part during their tenures and then leave. Each and every day of theirs spent here in the Supreme Court involves extensive reading and churning out judgments. Nobody had the time to take a pause and to reflect on how the institution of Supreme Court has evolved ever since it had its first sitting on the 28th day of January 1950. Honorable Dr. Justice Chandrachud has given us this day to think about the journey traveled by the Supreme Court and to celebrate the increasing role played by it in safeguarding the rights of the citizens of this country. It is also an occasion to pay homage to the judges who held the high office of the Supreme Court in 1950 and who laid the foundation of this great institution. I want to briefly talk about why the need of the Supreme Court has risen and how it was different from the earlier courts. At the time of India's independence, there was a federal court which had been created by the Government of India Act 1935. The federal court was practically the highest court on Indian territory, but it could only settle personal disputes or disputes between governments. It did not have the power to examine the validity of laws. In certain cases, parties could challenge orders of the federal court before the judicial committee of the Privy Council in London. The Constitution of India abolished both the Federal Court and the jurisdiction of the Judicial Committee of the Privy Council. It also gave the Supreme Court of India an important power of protecting the rights of citizens. The Supreme Court could now interpret the provisions of the Constitution. The Supreme Court could strike down laws which interfered with the rights of citizens. So the Supreme Court could do far more than what the federal court could do, and the citizens could challenge the mighty government and drag them to court in case of violation of their rights. The Supreme Court immediately used this power in the case of Ramesh Thapar versus State of Madras in the year 1950 itself, where it struck down a ban on dissenting media imposed by the government. Over the years, the Supreme Court has positioned itself as the most powerful court in the world with its power of judicial review of legislative and administrative actions and with creative use of its power under Article 142 of the Constitution. The Supreme Court has filled lacuna in the laws to make them more effective. It has framed rules even in absence of legislative backing. It has used power under Article 142 to grant divorce to couples in cases of breakdown of marriage where divorce is otherwise not proved under any of the recognized grounds. This shows that the Supreme Court is sensitive to the needs of the ordinary persons and is ready to go lengths to give them their due even when the legislature is yet to prove for it. We are happy that Honorable Dr. Justice Chandrachud has increased the number of working days in Supreme Court to 190 in the year 2024. The courts have extended cooperation to the bar and have accommodated the genuine requests of the lawyers. For instance, no adverse order were passed in Supreme Court due to non-appearance of any lawyer or litigant on the day of Pran Pratishtha at Ram Temple at Ayodhya in pursuance to my request to Honorable CJI on 21st January 2024. Just as India is celebrating Azadi Ka Amrit Mahotsav, this is the start of the 75th year of the Supreme Court and the beginning of Amrit Kal of this great institution. I congratulate Honorable Dr. Justice Chandrachud for having this ceremonial bench for reconnecting with the history of this highest temple of justice. Jai Bharat.
Today marks a significant day in constitutional history. The inaugural sitting of the Supreme Court of India was held 75 years ago on this day. The 6 judges of the Federal Court, led by Chief Justice Shri Harilal Kania, assembled for the first sitting of the Supreme Court of India. The event took place without much fanfare in the Prince's Chamber of the Building of Parliament from which the Federal Court functioned. For many, it would have seemed another day at the Federal Court because neither the composition nor the seat of the court were altered. On closer reflection, with the benefit of the hindsight of a succeeding generation, we see now that much had changed. On 28 January 1950, the judges assembled as judges of the highest appellate adjudicatory body in the world's largest democracy with wide, almost unrestricted powers to do justice. India was a newly formed republic which had overcome colonial oppression and navigated a period of incredible social, political, and legal turbulence to successfully draft and adopt its own constitution. Upon its establishment, the Supreme Court, as a custodian of the Constitution, shouldered a heavy burden of ensuring the development of the nation by protecting individual and group rights. What was a burden has survived decades of trials and triumphs, challenges and critiques, accolades and assaults, all along creating a uniquely Indian jurisprudence rooted and grounded in the expectations of her citizens. The Chief Justice's address at the inaugural sitting emphasized three principles that are necessary for the Supreme Court to function according to the constitutional mandate. The first is an independent judiciary, where the Supreme Court must be independent of the legislature and executive. The second is the judicial approach towards adjudication, which postulates that the Supreme Court must interpret the Constitution not as a rigid body of rules, but as a living organism. The third principle is that this court must secure the respect of citizens for it to establish itself as a legitimate institution. The confidence of our citizens is determinative of our own legitimacy. Much has changed in the 75 years since the inaugural. The Supreme Court itself and the legal regime in which it adjudicates have undergone extensive structural alterations. At its first sitting, the Supreme Court consisted of 6 judges. It now has a sanctioned strength of 34 judges. In 1950, this court sat in a bench of 6, even at preliminary hearings. 1,215 cases were instituted before the Supreme Court in 1950. Judgments were pronounced in 43 of those cases. The Supreme Court now sits in a bench of 2 judges, unless the case has been referred to a constitution bench or a bench of 3 judges. Between January and October 2023, 45,495 cases were instituted, and judgments were pronounced in more than 1,000 cases. With the Indian economy having undergone a radical transformation, new areas of law, telecommunications, insolvency and bankruptcy, and intellectual property have emerged. Conventional forms of alternate dispute mechanisms have metamorphosed into avatars dictated by the need for speed and business efficacy. The Supreme Court now deals with cases beyond the traditional classification of the civil, criminal, and constitutional. Disputes have become increasingly complex as the emerging areas of science and communication have reshaped our lives. In an interconnected world, neither the genesis of disputes nor their resolution exists in silos. However, despite the change in the world around us, the 3 principles highlighted during the inaugural sitting of this court continue to remain as relevant today to the functioning of an independent Supreme Court. This court has, in the last 75 years, faced old and new challenges in confronting the face of injustice and meeting the expectations of those at the receiving end of power. This court has, through the course of many years, charted its understanding of principles and developed innovative approaches to achieve the ideals of a democratic polity governed by the rule of law under a written constitution. We have received the baton in this long run from wise forebearers, judges and lawyers who walked and worked through these portals with fortitude and compassion. While much has changed in the world, the core of our ideals remains valid today as ever: our commitment to human dignity, liberty, equality, and fraternity. We are inheritors of a commitment where the welfare of the nation walks in tandem with the well-being of her citizens. The Constitution entrenches several institutional safeguards for an independent judiciary, such as a fixed retirement age and a bar against the alteration of the salary of judges after their appointment. However, these constitutional safeguards are not in themselves sufficient to ensure an independent judiciary. An independent judiciary does not merely mean the insulation of the institution from the executive and the legislative branches, but also the independence of individual judges in the performance of their roles as judges. The art of judging must be free of social and political pressure and from the inherent biases which human beings hold. Efforts are being made from within the institution to educate and sensitize judges across courts to unlearn their subconscious attitudes inculcated by social conditioning on gender, disability, race, caste, and sexuality. Over the course of years, this court has been called upon to navigate through the ambiguities of the law, resolve the conflict between individual and group rights, and the tussle between economic development and social reformation. This court has in every such instance stood up to the test of time and adjudicated these complex questions based on constitutional principle. Over the years, the court has understood the Constitution not merely as a document establishing a nation state and delineating the role of institutions of governance in the state, but also as a document with a transformative potential to reform social and political relationships. Once the transformative potential of the Constitution was unlocked by courts, the scope of the judicial function also enlarged. For example, the judgments interpreting the mandate of reservation in Articles 15 and 16 as a facet and not as an exception to equality, the limits placed on Parliament's power to amend the Constitution through the basic structure doctrine, and the dilution of the doctrine of political questions are important jurisprudential developments. Through them, this court has upheld core constitutional tenets by interpreting the Constitution as a living document. In none of those court terms were the answers to these questions clear as the day. Multiple benches of this court agreed and disagreed to arrive at these celebrated jurisprudential developments. It is in this dialogical process between different benches that a conclusion closest to the constitutional framework is reached. In multiple voices, we speak both to the present and the future. We may be, as it is sometimes called, a polyvocal court, but the strength of our polyvocal nature lies in its ability to adapt dialogue as a processual instrument in bringing together a synthesis of ideas. The synthesis in our court brings together diversity and respects inclusion. That is the true social ethos of the court, its social conscience. In the many that wear its apparel, the court emerges as one soul which knits together the bar and the bench in our desire to ensure justice to our citizens. The Constitution establishes a Supreme Court of India and confers on it wide-ranging powers to do justice. The court, as the highest appellate and constitutional court of the nation, derives but cannot rest its legitimacy solely on the Constitution. The legitimacy of this court is also derived from the confidence of citizens that it is a neutral and impartial arbiter of disputes which would deliver timely justice. This court has followed two approaches to enhance the faith in its justice delivery mechanism. First, by not conferring permanence upon judicial decisions, this court is cognizant that the law is not constant but is ever evolving. The space for disagreement is always open. In fact, the strongest jurisprudential developments of this court have undergone multiple rounds of litigation over the course of years, where the court has taken divergent views on questions of law. This court has gone about its task less attentive to its supremacy and more cognizant of the fact that the court, though final, is not infallible. It has not only opened itself up to critique, but has also taken positive steps to create spaces for the critique of its work. The Supreme Court, for its Golden Jubilee, published the book titled Supreme but Not Infallible, a compilation of essays written by leading practitioners celebrating and critiquing the work of the Supreme Court. The second approach of the court to enhance faith in the justice delivery system has been to increase access to courts by diluting the procedural rules for the institution of cases. This court was opened up to citizens in every corner of the nation, irrespective of their social and economic status. In 1985, 24,716 letter petitions were received in English, Hindi, and other regional languages. This number has since then undergone an exponential surge. In 2022, about 1,15,120 letter petitions were submitted to the Supreme Court, clearly indicating that the common person believes that they would be able to secure justice in these halls. These are letters of all hues, some of which fall within the ambit of the judicial function and others that do not. As judges, we need to know what lies within and outside the judicial function. The increase in access to courts does not necessarily translate into access to justice. This court has, over the course of years, faced immense difficulty in keeping up with the surge in the institution of cases. Currently, a total of 65,915 registered cases are pending before the Supreme Court. Much as we would like to reassure ourselves that the mounting pile represents the faith of citizens in the line, we need to ask hard questions on what needs to be done. There has to be a radical change in the approach to decision making. In our desire to ensure justice in each individual case, should we risk the court becoming dysfunctional? I believe that we have to have a common understanding of how we argue and how we decide, and above all, on the cases which we select for decision making. If we do not make hard choices and take difficult calls to resolve these pressing issues of the time, the euphoria generated from the past may well be short-lived. In recent years, this court has taken a positive approach towards decreasing the pendency of cases. In 2023, 49,818 cases were registered. 2,41,594 cases were listed for hearing, and 52,221 cases were disposed of, which is more than the number of cases registered. Technology has been a steadfast ally in decongesting pending matters. The electronic filing of cases has reduced the time between filing and curing defects. To address the pendency of old miscellaneous after-notice matters, directions have been issued to list the 7,430 miscellaneous after-notice matters that have been pending since 1993 on priority. Specialized benches for civil, criminal, direct and indirect tax matters, land acquisition, motor accident, personal law, labor and service cases have been constituted. Criminal cases in which the sentence of imprisonment is less than 3 years and the convict has undergone half or more than half the sentence have been identified and are listed for disposal on priority. Capital sentence cases are listed before a 3-judge bench. Pending Constitution bench references, which involve crucial questions about the interpretation of the Constitution, are listed on priority. This is of particular significance. All questions of law are yet to be settled by the Constitution bench. This is where we are today. Before I end, it is worth reflecting on perhaps the oldest challenge of all. The Supreme Court of India was, at its very core, designed to ensure that the exercise of power under the Constitution is legitimate and in accord with the rule of law. The occasion may be the exercise of power by the state against an individual, by the union against the states, by one state against another, or even one individual or group of individuals against another. The court is not the sole guarantor, but it is a final arbiter that power may be used to liberate, emancipate, and include, but never to oppress or ostracize. The novel challenges of today must never distract us from this most sacred duty of the court. The framers of the Constitution clothed the judges of the Supreme Court with immense power and independence and cast upon them the task of restricting the exercise of unbridled power. These are solemn duties. Since its founding, this court has constantly striven to fulfill them and address the challenges that it has faced. We are indebted to the bar for the valuable support we receive in deciding cases. All too often, the rich jurisprudence evolved by this court is viewed as a work of craftsmanship of the judges who author these decisions. The sleepless nights and the incisive mind of each lawyer ought not to be glossed over under the pen of the judge. The celebration of the history of this court is complete as we recognize the contribution of advocates to this court's rich tapestry. The Supreme Court of India has a staff of 2,148 persons. The tireless work of every staff member of the Supreme Court now and in the years since its founding towards ensuring the orderly functioning of the apex body, one day at a time, must be recognized and commended. Today is a day to celebrate this court's achievements, reflect on its deficiencies, and aspire for its advancement. Introspection is the art of bringing the seemingly unattainable within the line of vision. Thank you.
I have your lordship's permission to conclude the proceedings.
Presenting the Realme 12 Pro Series 5G.
The banal event, Vibrant Gujarat Global Summit, has turned into a benchmark event globally, and its success can be attributed to various factors, including the state government's proactive policies, infrastructure development, and efforts to attract both domestic and international investors. Participating in this summit holds immense significance as it marks the pioneering event in the Amrit Kal. On this occasion, we also welcome the Honorable Governor of Gujarat, Shri Acharya Devratji, and Honorable Chief Minister of Gujarat, Shri Bhupendra Bhai Patel. Thank you. We shall commence the significant inaugural session with a patriotic song, Jai Jai Garvi Gujarat, which was written by famous Gujarati poet Shri Narmad. The song that highlights the rich heritage, culture, bravery, and achievements of the land of Gujarat will be sung by world-renowned Shri Kirtidan Gadvi.
गुजरात ની સ્વર્ણ ભૂમિ પર ઉગ્યું સ્વર્ણ પ્રભાત જય ગુજરાત એ જય જય હો ગરવી ગુજરાત जय जय गरवी गुजरात, जय गरवी गुजरात, दीपे अरुण प्रभात, जय जय गरवी गुजरात, जय जय गरवी गुजरात, जय जय गरवी गुजरात, दीपे अरुण प्रभात, जय जय गरवी गुजरात, वंदन वंदन गुजरात तने वंदन, वंदन वंदन गुजरात तने वंदन, प्रकाश से जल कसुंबी प्रेम शौर्य अंकी, तू भणव भणव निज संतति सौने प्रेम भक्ति नीरी, ऊंची तुझ सुंदरता, जय जय गरवी गुजरात, जय गरवी गुजरात, जय जय गरवी गुजरात, दीपे अरुण प्रभात, जय जय गरवी गुजरात, वंदन वंदन गुजरात तने वंदन, गुजरात तने वंदन, उत्तर मायंबा मां, पूरव मां काली मां, छे दक्षिण दिशा करंत रक्षा कुंतेश्वर महादेव, ने सोमनाथ ने द्वारके, ने पश्चिम के रादेव, छे सहाय मां साक्षात, जय जय गरवी गुजरात, जय गरवी गुजरात, जय जय गरवी गुजरात, दीपे अरुण प्रभात, जय जय गरवी गुजरात, वंदन वंदन गुजरात तने वंदन, वंदन वंदन गुजरात तने वंदन, नदी तापी नर्मदा जोई, महीने बीती पण जोई, बड़ी जोई सुभद्रा सुध रमण ने रत्ना कर सागर, पर्वत ऊपर थी वीर पूर्वजों दे आशीष जय कर, संपे सोए सहुजा, जय जय गरवी गुजरात, जय गरवी गुजरात, जय जय गरवी गुजरात, दीपे अरुण प्रभात, जय जय गरवी गुजरात, वंदन वंदन गुजरात तने वंदन, वंदन वंदन गुजरात तने वंदन, ते अणहिलवाड़ नरम, ते शीत राज जैसन, ते रंग थकी पण अधिक सरस रंग थसे सपने मां, शुभ शकुन दिसे मदान, शोभ से प्रीति गई चेरा, जन घूमे नर्मदा सा, जय जय गरवी गुजरात, जय जय गरवी गुजरात, जय जय गरवी गुजरात, दीपे अरुण प्रभात, जय जय गरवी गुजरात, जय गरवी गुजरात, जय जय गरवी गुजरात, दीपे अरुण प्रभात,
Presenting the Realme 12 Pro Series 5G.
Thank you very much, artists, for the melodious presentation. Over the past 20 years, the Vibrant Gujarat Summit has achieved remarkable success in its development and growth initiatives, thereby transforming Gujarat into an economic powerhouse. Let's have a look at an audio-visual film narrating the success story, that is, Vibrant Gujarat Global Summit.